Hello and welcome. My name is Jeremy Glover and it's my pleasure to welcome you all to our final Fenwick ELLIOTT webinar for 2021. And this week we're taking a look at defects and more specifically the question of damages arising from defects. And that will include a mix of some of the practical, legal, contractual issues that we've found ourselves dealing with over the past few years. And joining us this week is one of my colleagues from Fenwick ELLIOTT, partner Lucinda Robinson. And before she joined us, Lucinda had been working in-house with a leading supplier in the construction industry, which I think gives her an additional focus point for some of the issues we're talking about. And also by Felicity Dynes, the barrister at Atkin Chambers. I remember working with Felicity on an arbitration where we asked her to carry out a task which involved trying to clear the wood to see the trees, something she did with precision and clarity. So it's no surprise to me that she's described in the legal directories as being hands-on, measured, responsive, very incisive, and well able to deal with last-minute variations in her stride. All skills you need with dealing with claims about defects. So before I hand over to them, just a reminder that you're all on mute. Please do send in questions. You should be able to find the slides on our website later in the week. A link is going to be put on the chat during the webinar. But Lucinda, the floor is yours.
Thanks very much, Jeremy, and good morning to everybody. Thanks very much for joining us this morning, or this afternoon now, I believe. When we first planned this session, defects and damages, it seemed like quite a discrete topic, but once we dived into the detail, it soon became obvious that it's actually immense. So as Jeremy suggested, we have honed in more on the damages side than on the defects. And that does mean there's a few points to bear in mind about what we will and won't be covering. So we are going to stick to the realm of contract law, and we're not going to dive into tort or the defective premises Act this morning. And even within contract, we are going to stick to or have to make a few assumptions. So we're going to assume there is a defect. We're going to assume the defect is a breach of contract, and we're going to assume the defect has caused the loss, because each and every one of those topics deserves a webinar in its own right. So maybe watch this space for 2022. What we are going to cover is what is set out on this slide. So what losses are recoverable and how are they measured? How claims for loss can be undermined and restricted? Practical matters around evidence and records. And we're going to finish off with a summary of what our top tips for claimants and defendants when dealing with damages. So starting with that first point of what losses are recoverable. The starting point, as ever, and as you will have heard many times, is the contract. So please always read your contract first of all, because it will specify, or probably will specify, some actions that a claimant needs to take before it can bring a claim. For example, perhaps the employer has to allow a defendant contractor time to rectify defects before it can bring in someone else to do that and claim the costs. It might also specify some limits on what can be recovered, which Felicity is going to talk about shortly, or perhaps include indemnities, which will effectively increase what can be recovered. Now, indemnities are another subject worthy of their own webinar, but in brief, if you have the benefit of an indemnity, then chances are you're going to be able to recover more than you otherwise would, and it will be harder for a defendant to argue your loss was unreasonable, unforeseeable, or not properly mitigated. So, once you have understood what your particular contractual framework provides, then you can go on to assess your claim within that framework. So let's have a look at how to do that. Now, the general principles when it comes to recovering damages are that damages are there to compensate the claimant for its expectation loss. So the idea is that the claimant should be put back into the position it would have been in had the defect not happened, had the breach not happened. They are not there to penalise the defendant, and they are not intended to reward the claimant. Now, the claimant can recover the loss it can show to be attributable to the breach, so it needs to prove that the loss has come from that breach. If the loss is too far remote from that breach, then it is not going to be recoverable. And the test for remoteness, and therefore what can be recovered, is found in that very familiar case, the old chestnuts, Hadley and Baxendale. Now, in this case, The claimant had a mill powered by a steam engine, the crankshaft broke, and the claimant engaged the defendant to transport the crankshaft to the repair shed, not his real name. They were late. The claimant could not operate the mill, and so they had to buy in some flour to supply their customers, and as a result, they lost some profits. Now, when considering what the claimant could recover because of this problem, the court was quite clear that claimants cannot generally recover every single penny of their loss, as much as they might like to and as much as they might feel they're entitled to. They can't. The recoverable losses need to be confined to those that are foreseeable. And the court went on to set out the now quite famous two categories of recoverable losses, what we've gone on to recognise as direct and indirect loss. So let's take each of these in turn and start with direct losses. I think I might have gone too far there. There we go. So direct losses are those which arise naturally from the breach. They are the losses you would expect to happen if that particular breach of contract occurred. So I'm going to consider some examples of direct losses in the light of what you would expect to happen if there is a defect. So let's have a look at what these can include. First is the most obvious, being the cost of cure or the reinstatement cost. So this is about repairing or replacing the defective works, the defective assets, which you would expect to be a direct loss because it's the obvious thing that needs to be done when faced with a defect. And these costs might include design fees, purchase of equipment and material, the cost of the new works, managing those works, etc. And when looking at what reinstatement costs can be recovered, the court is going to look at what has been caused by the defect itself, what is foreseeable and what it is reasonable to hold the defendant liable for. So what's attributable to the defect, what's foreseeable, what is reasonable. All three of those are separate things, but there is a degree of overlap between them, and the court will consider them all in the round. One issue that pops up frequently is whether or not the claimant is entitled to simply knock down whatever defective asset it's been left with and replace it completely, or whether its recoverable losses are going to be what it would cost to repair. Now, the repair versus replacement argument was played out in a case called McGlynn and Waltham. Now, here there was a great house called Maison d'Or in Jersey, but it was demolished 3 years after sitting empty whilst contractors and consultants tried to work out how to repair numerous defects. McGlynn claimed for the replacement costs, saying he was entitled to knock it down because it was a load of rubbish. Alternatively, he wanted his repair costs, please. He was allowed only the repair costs and not the full replacement costs. The court decided that demolition should really be a last resort, and in this particular case, the demolition wasn't really down to each of the several defendants. Looked at in the round, McGlynn was generally dissatisfied with Maison d'Or. He just was never that happy with it, really. And the decision to demolish the building was based on the cumulative effect of a large number of unconnected items, many of which were aesthetic defects rather than structural problems, and different people were responsible for different things. So in those circumstances, the court didn't think it was reasonable to hold the contractors liable for the complete demolition and rebuild, especially because there were no plans in place on this particular occasion for the rebuild. So there's no assurance that that was even going to happen. But what if the claimant actually has no intention of doing either? It doesn't intend to repair, it doesn't intend to replace, and it's going to just keep the asset that it's got. Or what if the costs of repair exceedingly outweigh the benefit of actually carrying out that repair and would be completely disproportionate? In these circumstances, the court usually finds that actually the cost of cure is not the appropriate or reasonable measure of damages, and an alternative is necessary. And what they would usually then look at is the diminution in value, so the reduction in value of the affected asset caused by the defect, and chances are a little bit of expert help might be needed there to assess what that change or reduction is. But if there is no diminution in value, it is still possible to recover some compensation for loss of amenity. And the classic illustration is Ruxley and Forsyth, the famous swimming pool case. So here you'll remember the pool was constructed and it was fit for diving and for swimming, but it wasn't as deep as it should have been. Now the case went all the way to the House of Lords, who confirmed that in this particular instance, the cost of cure was unreasonable. There was no diminution in value, but the claimant could have some nominal damages for loss of immunity because he didn't really get what he'd asked for. And that, in the circumstances, was what was reasonable to recover. So let's move on to some other heads of loss that commonly arise from defect claims. Another is management time, dealing with the defect and the repair of it and that sort of thing. Now, management time is one that lots of people try to claim, but not always with success because it can be difficult to prove. And for guidance on how to prove your loss in this situation, look no further than Aerospace Publishing and Thames Water. Here, the Court of Appeal said you had to prove that either additional staff had been brought in because of the breach, in which case you can claim the cost of those additional people, or that existing staff time had been diverted. And this is quite often the position that claimants will find themselves in, and what they need to do to prove that the existing staff time should be recovered is show the fact and extent of the diversion and that the diversion caused significant disruption to the business. If you can do that through a combination of good record keeping and witness evidence, more on that later, then you may be able to recover the cost of the staff wages for the relevant period. Another common direct cost is loss of profits. Now, there's been a little bit of chatter over whether or not loss of profits is properly a direct loss or an indirect loss. And more recent case law, or case law generally, is suggesting actually a lot of the time it is a direct loss because if you take the example, for example, of a defect that might prevent production in a manufacturing facility, for example, then the profits that are lost because the defect is preventing production are the natural consequence of that breach. So loss of profits often will be First Limb, Hadley and Baxendale, and a direct loss. However, you do need to make sure you consider the circumstances in each case, and as we will find out, sometimes it's an indirect loss. Another type of loss that can be recovered is perhaps a little bit less obvious, and that can be compensation to customers, for example. So in GB Gas and Accenture, there were several heads of loss that don't fit into any of the categories I've already talked about, but were still considered to be a natural consequence of the loss, direct loss, and therefore recoverable. And these included compensation paid to customers when a billing system that had been installed for GB Gas caused the customers some problems, and GB Gas had to settle the complaints from the customers. GB Gas were also entitled to recover charges they had incurred because of the mistakes in this billing system, additional borrowing costs that it had to take out extra loans to bear the cost of the problems it was dealing with, and administration costs it incurred in trying to sort everything out and deal with the customers were also recoverable. So this goes to show that although there's some obvious heads of loss that will happen when you have a defect, sometimes there are other things as well, and in your particular situation you just need to think about exactly what they might be. Skipping on to indirect losses, these are the ones that are not a natural consequence of the breach but might reasonably be supposed to have been in the contemplation of the parties at the time the contract was made. In other words, if the defendant knew a particular loss would arise if he didn't fulfil his part of the deal, then he takes the risk of that event occurring if he breaks his promise. If he knew nothing about it, it wouldn't be fair to make him pay. And how this works is shown quite nicely in the story or case of Victoria Laundries. A boiler in a laundry broke down and had to be sent away for repairs. It was returned late, which seems to be a common theme. And during the delay period, the laundry lost its ordinary profits. They were recoverable, no issues there. However, over and above its ordinary work, the laundry had secured a large contract, which the defendant knew nothing about. And the delay to the boiler meant the laundry couldn't honour its commitment under that special contract, and it lost its additional income. The court found that wasn't recoverable because it was not a natural consequence of the breach, and it had not been in the contemplation of both parties when the contract was made. So the moral of that story is that if you want to recover indirect loss, you need a crystal ball, because you need to know what it is at the outset of your contract, so the potential claimant can bring those special contracts, special arrangements to the attention of the potential defendant. And this is why in subcontracts, for example, you see clauses saying the subbie has seen, read and learned by heart the main contract and everything in it. And it's so that if the subcontractor puts the contractor in breach of the main contract, you cannot say, well, you didn't tell me about it, so I can't be responsible for that. And the same applies when employers require the main contractor to sign up to a clause saying he has read and understood a pile of third-party agreements. The main contractor is taking on the risk of indirect losses he may not have had to worry about if they hadn't been brought to his attention. Just very quickly, and then I'm going to hand over to Felicity. Oops, getting carried away with these slides. There we go. Sometimes it is considered that indirect and consequential loss are terms that can be used interchangeably, and that was the traditional approach. However, there have been a few cases where the court has said that consequential should be given its ordinary meaning, and the facts of each case should be considered to establish what was in fact a consequence of the breach. And that's a slightly wider concept than the idea of indirect loss under Hadley and Baxendale. In a more recent case in 2020, the traditional approach has been applied, so it may be that they are the same after all, but this needs a little bit of thought if you're dealing with, for example, an exclusion clause talking about consequential losses. And why does all of this matter? Well, it's exactly that exclusion clause point, which Felicity is going to talk about shortly. But if contracts are including exclusion clauses and direct and or consequential losses are mentioned, well, the parties need to know what it is that they're dealing with, so they know what is and is not excluded. And now I am going to hand over to Felicity to talk about and restricting claims.
Hi, good afternoon, everyone. As a defendant, you are likely to be in quite a difficult position if there's a justifiable case of defective work being made against you. However, that does not mean that there aren't avenues that you can go down to restrict or limit your liability. I'm afraid we're going to race through these slightly, but we'll move on to the key points to consider. Firstly, the same as if you were the claimant, look at your contract, see what contractual limitations there are, and whether your contract includes terms which will assist you in limiting liability for the consequences of defective work. Secondly, can you make any allegations of a failure by the claimant to mitigate its loss, which has had an identifiable impact on the amount of loss suffered? Thirdly, whether, as Lucinda has already discussed, the types of losses claimed can be argued to be too remote and so not recoverable. Would you never have envisaged such losses as a result of the defective work? If that's the case, then there may be an argument that the damage is too remote. I don't propose to cover that point further, as it's already been covered in a bit of detail by Lucinda. But even if the allegations of defective work are valid, that doesn't automatically mean that whatever losses the claimant is claiming are recoverable. And finally, although not strictly a legal argument in defence of a claim, defendants should consider whether losses can be curtailed or limited by making a competitive offer to settle, either in the hopes of the matter itself settling and legal and expert costs not needing to be incurred, or alternatively as protection against an award of costs. Contractual limitations. The first point of call, whether claimant or defendant is the contract. Is there an overall cap on liability in your contract? These are often in a form which caps liability at the total of the contract price, and this can be particularly important where, for instance, the defendant is somebody like a piling subcontractor who, if responsible for defective piling, their work can have a significant impact on others' work and therefore can be very costly to repair. Next, is there an exclusion of liability clause excluding claims for certain types of losses, or for example, for indirect losses, commonly loss of profit, loss of use, that kind of thing? Thirdly, is there a contractual code which sets out what can be claimed in respect of a failure by a contractor to rectify defective works? Such a provision was considered in Mull and Hutton. In that case, it was clause 2.30 of the JCT intermediate form of contract. The question there was whether an appropriate deduction for defects which hadn't been rectified should be limited to what it would have cost under the contract, by reference to contract rates, for example, and what it would have cost the contractor to carry out, or whether it should be viewed more broadly as what's appropriate in all the circumstances. The latter view prevailed. However, such clauses do make it easier to argue, particularly if there's an exclusive remedies clause, that only the direct and reasonable costs of rectifying defects are recoverable. Next, is there a clause requiring the contractor to be given an opportunity to rectify defects? If so, and the contractor has not been afforded such an opportunity, then it may be possible to argue that a lower amount should be recoverable to reflect the cost to the contractor, or even that no amount should be recoverable if the contractor could himself, for example, have got his supply chain to rectify the defect at no cost to him. Finally, is there a net contribution clause? This may not be relevant if there's no one else who might be responsible for the defect, but if there are other parties who are in part responsible, then a defendant may wish to rely on a net contribution clause to say that this is not all loss caused by me. These can provide a significant advantage to defendants because they don't require the other responsible party to be joined to proceedings, and they don't require a loss to be established against you first before you seek to pass it on to another party. And they also protect defendants from other parties' insolvencies. That means that the claimant would bear the risk of the insolvency rather than the defendant. Oops. Next subtopic is failure to mitigate. What is a failure to mitigate? There's no duty, there's no positive duty to mitigate as such, but rather an argument on causation that a defendant can deploy. The legal test is not could it have been done cheaper, as sometimes seems to be inferred, but is essentially did the claimant unreasonably fail to take steps, or did it take steps no reasonable person would have taken, and did this increase the harm suffered? Lord Justice Potter in Standard Chartered Bank against Pakistan National Shipping describes it as being causation and mitigation are two sides of the same coin. It can be characterised as an issue of causation in the sense that if the damage has been caused or exacerbated by the claimant's unreasonable conduct or inaction, then to that extent it has not been caused by the defendant's tort or breach of contract. The burden of proof is on the defendant to prove a failure to mitigate. There are two elements to this. Firstly, the defendant must prove that there was a failure to mitigate, i.e. that there was unreasonable behaviour by the claimant. And secondly, the defendant must prove that there was a consequent increase in the harm suffered. So not only was it unreasonable for the claimant to do what they did, but if it had not done it, then it would not have suffered the loss it did, or it would not have suffered part of the loss that it did. On this slide, I've set out various arguments on failure to mitigate that could be advanced in respect of a claim for defects. As we'll see in a moment, it is usually an uphill struggle to prove a failure to mitigate. The burden on the defendant is a high one. There's not much law on the point, but the first of these bullet points I think is an interesting one. in Woodlands Oak and Conwell, the employer was not permitted to make deductions from the final account for snagging and defects because he had not given the contractor an opportunity to rectify them himself. Reliance was not placed on a particular contract clause, but the court considered that failure to go first to the contractor was a failure to mitigate loss, as the contractor would have been able to rectify the defects at no cost, and it seems that there was no adequate justification for not going to the contractor first. Then if we turn to what the courts have said, the starting point, I think, is probably Lord Macmillan in Banco de Portugal against Waterlow and Sons. And he said, where the sufferer from a breach of contract finds himself in consequence of that breach placed in a position of embarrassment, the measures which he may be driven to adopt in order to extricate himself ought not to be weighed in nice scales at the instance of the party whose breach of contract has occasioned the difficulty. This really, I think, emphasises that the claimant must have behaved in a very odd manner or done something that nobody else would be doing in their situation in order for a case on failure to mitigate to succeed. Similarly, in the case of Harlow and Jones, Mr. Justice Roskill, as he then was, says, of course, the plaintiff always has to act reasonably, and of course he has to do what is reasonable to mitigate his damages, but he's not bound to nurse the interests of the contract breaker. And so long as he acts reasonably at the time, it ill lies in the mouth of the contract breaker to turn around afterwards and complain in order to reduce his own liability to a plaintiff, that the plaintiff failed to do that which perhaps with hindsight he might have done. So the claimant does not have to go out of his way to reduce the costs that he's incurring, but he does have to act sensibly. Then more recently, Mr. Justice Leggett he then was considered a failure to mitigate in Thai Airways and KI Holdings. And the point is emphasised again that the claimant is not expected to take steps which would involve unreasonable expense, risk or inconvenience. And there is often a range of responses available to the claimant which will be regarded as reasonable. And quoting Lord Justice Potter, he said, if there's more than one reasonable response open to the wrong party, the wrongdoer has no right to determine his choice. So although this is an argument that's frequently deployed by defendants, it has to be done quite carefully in order to have a chance of succeeding. And it has to be framed around really quite unreasonable behaviour from the claimant. Then, before I hand back to Lucinda, just covering the final point, which is offers to settle. And there is always an advantage to making a timely and competitive offer to settle if essentially you think that on a technical basis there is liability for defective work. There are many different ways of doing this. If the claim consists of various matters, one of which is defects, then an offer could be made to settle in respect of particular defects only by way of call-to-bank offer, or a lump sum offer could be made if it's not clear which amounts would necessarily be attributable to which defects, and it's thought that that may be more attractive to the claimant and more difficult to turn away. Alternatively, another version of offer is to undertake the remediation or rectification yourself. That has the advantage of giving a defendant control over the scope and pace of the remedial scheme, and therefore greater control over the costs. So those are the key points to consider in defending a claim for damages for defects. And I'm going to hand back to Lucinda now, who's going to talk through some practical matters about witnesses.
Yes, because it's all very well having a claim for loss and being able to work out what that claim is and how much it's worth and whether it can be attacked. But Any claim has to be proven or it won't be successful at all. And for that, we need evidence. So as Felicity says, I'm going to have a look at witnesses, and then I'm going to hand back to her to have a look at records. So with these witnesses then, the claimant will need to decide what the witnesses are going to talk about and who is best to cover each of the points that need to be proven. So starting with the what, and going back to some of the heads of loss we looked at earlier, when it comes to repair and replacement, so the reinstatement losses, someone will need to explain what repair works were procured and why, as well as how much they cost and whether the costs were all attributable to the defect and whether they were reasonable in amount and why. And the witness will also need to explain things like whether there was a tender process, if so, how that worked and how tenders were assessed, and ultimately why the particular contractor was chosen and why its rates seemed to be reasonable. The witness will have to go on to explain how costs were managed during the works. So were payment applications scrutinised and challenged, and how? Were variations properly instructed and assessed, and did they really arise from the defect or were they caused by something else? And if the works have not yet been carried out, the witnesses will need to explain that they are intended to be carried out, if that's the case, and if so, how the costs of those repairs have been estimated. In terms of a loss of profit claim, the claimant is obviously going to need to explain how its profits have suffered because, for example, it may have had to turn away other projects, or it has not been able to open if, for example, it was a production unit or a business building, for example. The appropriate witnesses in this instance may come from the accounts or the commercial team who have greater insight into the finances of the organisation. And if settlements have been reached with third parties along the way and the claimant is seeking to pass those on, then it needs to explain why it was reasonable to settle and why the settlement amount was reasonable. So there is quite a lot to explain in terms of the whys and hows and wherefores. In addition to that, the witnesses are going to need to confirm that payment has in fact been made. And again, you might be looking to someone from the accounts team on that. So the witnesses to actually prove these defects, damages, claims are likely to come from different parts of the business. So yes, of course, the project team and the commercial team involved with that project, but also actually within the central corporate functions of the business as well. And when it comes to selecting who those witnesses are, there are a few factors that you need to consider. And some of the ones that will be common to all cases will be things like, what was the role of that particular witness and what was their first-hand knowledge of the issue in question? The evidence is going to carry more weight, for example, if they were personally involved in the project. Other considerations might be, are they still employed by the claimant? If not, are they contactable and are they likely to be on good terms? And following on from that, how do these individuals present as witnesses? Everyone is nervous, nobody likes being in the witness box, but are these people straightforward in their approach? Are they capable of talking to the court, standing up to cross-examination and just putting things forward as calmly as they can? And just as a reminder for those drafting witness statements, the new Practice Direction 57AC and Statement of Best Practice now applies, and that involves slightly, well, quite more strict rules about how witness statements should be drafted in an effort to cut back on over-reliance on the contents of documents and too much legal involvement in the witness's recollections of what in fact happened. There is more pressure on the individual witness to remember what went on. And for that reason, as well as others, on a practical note, involving witnesses in a case as early as you can is quite helpful because it means that they're more likely to invest themselves in that case, help you with the preparation, help you prepare experts, which we'll come on to it in a minute, and their recollection will become refreshed through that process, which will help them when it comes to drafting their statement. So moving on to experts. Experts are always going to be really important when it comes to quantum, because there is usually so much number crunching to be done and poring over detailed records, which Felicity will talk about, but poring over records of what costs were incurred and why, and the nitty-gritty of all those payment applications. Now, the expert is going to assess what loss has been incurred and also opine on whether or not it considers the loss to be reasonable. So when it comes to ensuring your expert is as robust as possible, there are three broad areas to work on, which are shown in this slide here. So if we go on to the next one, then we can break this down into a little bit more detail. So first and foremost, when picking an expert, make sure they are in fact an expert. I have known experts to be embarrassed in cross-examination when opposing counsel has remarked that his dog had received the same certificate from an online course as the expert had. So just be a little bit careful on who you choose. Second, you need to be absolutely certain that the expert is independent and impartial. And there have been a spate of cases on this recently, so it's quite current in the minds of the judges. And we do have some up-to-date information and guidance from them. So just taking two examples, in Essex County Council and UBB Waste, the technical expert, or one of the technical experts, was also the managing director of a firm of consulting engineers who'd provided significant design advice to UBB during the works. And he acted as an expert on the proviso that a claim against his firm would be dropped. So he had a vested interest in UBB's successful defence. And the judge said that this conflict of interest should have been disclosed at the outset and permission sought to rely on that individual as an expert, which may not have been granted. His evidence in the end was admitted, but there was a great big caution notice stamped on it, so that the judge had in mind when considering his evidence that perhaps it wasn't as independent as it should have been. In another case, Blackpool Borough Council and Volker Fitzpatrick, the parties' respective experts agreed to use a single testing house to provide data on which they could each opine, but the claimant's experts then contacted the testing house unilaterally to request some additional tests. It did go on to share the results of those tests with the defendant, but the defendant decided that it was worth a pop to see whether they could get the claimant's expert evidence thrown out, and brought an application to that end. And the court noted that the claimant's expert behaviour was really not best practice, and it should have copied in the defendant to its communications with the testing house. In the end, the court decided, again, the expert wasn't in breach of his duties, but the whole point that this had to be discussed at all obviously casts something of a shadow over that expert's evidence. Finally, point number 3 is that quantum experts need to be well prepared, and this is true of any expert, but obviously today we're focusing on the quantum folk. And it helps to bring the quantum experts in early. Sometimes it's sort of left a bit towards the end and sort of brought in just to crunch some numbers at a later stage, but actually it helps the experts if they are brought in early doors, so that they've got time to understand the story of what costs were incurred and why, so they can work their way through the witness statements and understand what's going on, pose questions to the claim team, and also scrutinise all the data about costs. I mean, there can be volumes of purchase orders, invoices, payment statements, various instructions and variation information that they need to comb through, and that takes up time. So Felicity will talk about records in a minute, so I will just leave it here on the note that quantum experts need a chance to prepare properly. And, oh, sorry Felicity, I've gone too far.
Don't worry, that's fine. Thanks. So record keeping is absolutely essential if you want to get your claim up and running and have a chance of success. records are needed in order to establish on the balance of probabilities that you have suffered the loss that you allege you've suffered, and that is as a result of the defects that you're complaining about. Very quickly then, what kinds of records are needed for the different heads of loss, and I'll also cover briefly the need for putting systems in place in order to maintain and formalise your records so that they can be used by the experts, as Lucinda mentioned. For your remedial works, you'll need things like any invitation to tender in respect of the remedial works. You'll need details of the scope of works and any contracts or instructions or variations if you're instructing existing contractors on site to rectify them. Make sure that you get your contractors to keep detailed timesheets or descriptions of work carried out so that those can be linked back to the particular defect. That's particularly important where you've got other works ongoing at the time, and it's not just getting somebody back in to look at a particular defect. Any expert or specialist advice on remedial schemes should be part of the records that you keep. Also invoices, applications for payment, payment certificates, so that you're tracking the amounts that are incurred in respect of particular defects and rectification works. And you are also likely to need evidence of payments. Obviously, if you've got the invoices, you've got the amount that you're liable to pay or arguably liable to pay. But given that in the first instance in court proceedings or in arbitration, it will be a quantity surveying expert who is assessing your claim, not in fact the court or the tribunal, they will want to see evidence that payment has in fact been made. And the court or tribunal will then see your case through the prism of the expert evidence. So that's particularly important. Management time, Lucinda talked about it earlier, but you will need things like payroll information and overheads information. And it's important to ask any employees to keep timesheets of time spent on particular defects or management of rectification works. Then it's easier to identify the element of your staff costs that's attributable to the defects. Where a claim's made for alternative accommodation because the defective work has meant that you've had to move out in order to carry out rectification, you'll need receipts or invoices. For a claim for loss of profits, it will be hugely fact dependent, but likely to be driven by whatever you're asked for by a relevant expert, but will include things like valuation of the business and accounts and records as to valuation of the asset. You'll need to put systems in place in order to keep your records. This is more important in bigger defects claims because there's simply more material. But as soon as you can, give instructions to your business or to the contractors to maintain the particular records that you think you're going to need. Obtain advice from your quantity surveying expert or a quantity surveyor on the project as to what might be useful. Make sure that you have a document control system in place for recording and collating costs against individual defects for the big cases, and bring in additional support if that's what's needed. And as Lucinda mentioned before, if you do need additional support, then that is something that you could claim as well. Then I'll hand back to Lucinda to start on top tips.
Yes, so we've just summarised here at the end the top tips for claimants and for defendants as a bit of a wrap up of what we've been saying today. So starting with the claimants, what are the top tips for claimants seeking to bring a claim for damages? Well, first of all, check what the contract says and see if you have to clear any hurdles before you can bring the claim, or if there are any limits to bear in mind or indemnities to make use of. Then you need to work out what your claim is for. So ascertain what types of loss have been caused by the defect. And at the beginning of things, it's worth going wide and really trying to brainstorm exactly what type of losses have been caused. You can do the refinement a bit later when you come to really sort of narrowing down your claim and honing in on things. But just at the very beginning, think through exactly what losses have been caused. Then you can work out whether or not they are direct or indirect. And then you can proceed to calculate how much has been incurred in relation to each of those heads of loss. So that's one thing, but the next thing, of course, is proving it, and that is really, or can be, the tough bit. So first and foremost, manage your data, as Felicity says, put some systems in place to ensure the records are kept and organised, and you have the records to show what has been incurred, how and why decisions being made are reasonable. Record those steps and save the document somewhere easily retrievable. And then identify the best witnesses to explain the losses and how they've been incurred. Involve them in the case so they can refamiliarise themselves with what's been happening and so that they can get to grips with their documents again. And finally, find a good expert. Make sure you scrutinise the qualifications, the experience of those experts. See if you can get some recommendations, speak to others who've used them. See, you can normally do a bit of a Google search to see whether or not they have come up or given evidence in reported cases, and you can look at what the judge thought of them in those cases. And of course, you can interview a few experts as well to really get a feel for what their experience in the box is, how well they prepare reports and how well they know their subject matter. And let's see what Felicity says about the defendant.
So just recapping really on what the defendant should be doing. Firstly, checking the contract for contractual hooks for limiting or reducing liability. I've set those out on the slide. Secondly, considering causation. Does the expert and factual evidence in fact support the case on liability and quantum? Is there any key evidence or documentation missing? Is there any unreasonable conduct? And are any of the damages claimed too remote? Thirdly, consider settlement or protection by making settlement offers. And fourthly, I think it's an important point to make, to be selective. Do not make every point that you can possibly think of under the sun in defence of a damages claim for defects, particularly where you think that the case on breach is made out. Stick to the arguments with merit. Concede where sensible and focus on points which have reasonable prospects of reducing the quantum of any liability. And beware of pleading a failure to mitigate just because the works could have been done more cheaply. That's unlikely to curry favour with a court or tribunal unless the works were in fact carried out at exorbitant cost. So that's it, I think. We'll hand back to Jeremy.
No, I mean, thank you both very much. That was a really thorough explanation of many of the things that we need to think about. You can tell that it engaged the audience's interest because we had a number of questions coming in. Happily, Lucinda, you've answered the question about experts that came in. Someone's asking about sort of what tips or guidance you may have for selecting the right expert, because as you've stressed, it's very, very important. But earlier on, Lucinda, you were talking about repair and replacement costs. One of our questioners has provided a scenario where a contractor doesn't successfully make good a defect and the employer retains the retention monies, but then the employer does not rectify the defect either. And I think at its heart there, I mean, you've got a sort of a scenario that's quite common. What happens if a claimant, can a claimant recover repair costs if they haven't carried out the repair works?
Well, there's no rule that says you have to have spent the money before you can recover it. So If the employer does intend to carry out the repair works, and for example, it can draw on evidence that it is putting together some plans, that it's got some estimated costs, that the real intention is there to go ahead with it, then chances are they will be able to recover the costs. If the evidence in fact suggests that they've got no intention of repairing anything anyway, then the full cost of repair is unlikely to be a reasonable recovery, and they probably won't get, well, they wouldn't get the full amount, I don't think.
Okay, thank you. Got another another scenario. A hotel cannot open because of extensive defects, and so there's a loss of profit. But there's also a liquidated damages clause that reflects the loss of income, and perhaps may have been designed to reflect loss of profit as well. To what extent is there sort of crossover? So you've been talking about damages for defects, and here there's the right to recover liquidated damages. Felicity, do you have a view on that?
So I think it depends where the works are. If practical completion has already occurred, then it's more likely than not that liquidated damages will no longer apply to the period in which the defect rectification works are carrying out. So following the Supreme Court's recent judgment in Triple Point, your liquidated damages for delay are likely to end at the point where you've got practical completion or termination. And so if you're carrying out defect rectification after that point, then your other losses, such as delay costs and loss of income, would be prima facie recoverable, subject to any restrictions in the contract.
Okay, thank you. Had a question. I mean, sometimes when repairs are being carried out, residents have to move out. Had a question sort of specifically about that. What damages are residents of high-end apartments entitled to in terms of reaccommodating while the repairs are being carried out?
Well, shall I take that one? Is that all right with you?
Yeah.
On that one, the claimant is entitled to recover the direct or indirect losses flowing from the breach. So if the defect is what has caused the need to move out, then yes, the costs of having to live somewhere else temporarily are going to be recoverable on the face of it, because for example, if you had a breach where there was just huge flooding through the ceiling for days and days and it wrecked the place, then obviously you couldn't live in it. If it was slightly more tenuous and perhaps you didn't necessarily need to move out, then there might be more of an argument for the defendant to bring that those losses should not be recoverable. The other thing to flag is that there have been a few residential, or there have been some suggestions in cases involving residential occupiers that the residents might be entitled to a very small amount for their distress and inconvenience in that sort of situation. So if you're the claimant, it would be worth putting in an amount for that as well. The amounts haven't been very high. They've only been a few £100s, but
okay, thank you. If an employer has a demand bond for performance, can this be a better route or better way to secure defects or damages for defects instead of going through the damages route? I mean, can you use the bond to try and get things done?
Should I take that one?
Yeah, please.
Yeah. I think it depends on the terms of the bond. If it's non-demand bond and you have unrectified defects, which either you've asked the contractor to rectify and they haven't rectified them, or there's no obligation to get the contractor to rectify them, for instance, because their performance has been so poor that you don't trust them to rectify them, then you could resort to using the on-demand bond to cover the costs which you say are attributable to those defects. That may be a quick route to getting the money so that you can do the works or cover the costs. The difficulty then might be that the contractor will challenge it and then seek to get the money back, and so you'll still end up having to argue on the defects. So there's still the need to keep all the proper records and make sure that you document everything and can justify the costs that you're claiming on the on-demand bond. It may be that you cannot claim the whole of the bond and that you have to restrict yourself to what you think is the reasonable cost of rectifying the defects, or putting you in the position that you would have been but for the breach of contract giving rise to the defect.
Okay, brilliant, thank you. And finally, and I think this question is sort of related to the first question I was asking. If defects works remain outstanding after the defects rectification period and the contractor refuses to complete them, saying you're out of time, is there any remedy available to the client? I mean, can they deduct money from the retention? Lucinda?
Yes, I mean, have a look at the contract to see whether it gives the employer a clear right to bring in somebody else to complete the works or have them completed themselves in that situation. If so, then that's really helpful for the employer, and it can then go on and claim the cost back from the defendant, and it might do that through deducting from the retention. Even if there isn't such a clause, if the opportunity has been given to the contractor and they've clearly refused, the claimant then will be able to bring a claim for a breach of that particular obligation. But also, if the thing that needs to be repaired is a defect, then there'll probably be a breach of contract in that respect as well. So they'll be able to bring a claim for breach and establish what the loss is attributable to that, and that probably is the cost of cure. So yes, they could do that, and if they are still holding retention, then yeah, hold it back.
Brilliant. Thank you both again very much for your presentation and for dealing with the questions. So just starting to draw things to a close now. As I said, this is our final webinar for 2021. We are back on the 13th of January 2022 when Fenwick Elliott partner Ted Lowry will be joined by Fiona Parkin QC from Atkin Chambers, and they'll be providing a case law update in relation to PFI contracts. So thank you all very much for your attention today, and it simply remains for me to wish everyone a happy Christmas and also a happy, healthy, and perhaps above all a safe New Year. Thank you very much.